Chattanooga.com reports that longtime prosecutor Rodney Strong is leaving Neal Pinkston's service. Neal Pinkston is the District Attorney General, the DAG, the DAG, and he is part of our Fellowship of the Finger here in Chattanooga and Hamilton County. The Fellowship of the Finger is a friendly group comprising police officers and police departments around the county itself and its sheriff's department, and then the state with its peace and tranquility standard that says that anyone who violates the peace and tranquility of the state must be accused by the Fellowship of the Finger. And the Fellowship of the Finger is this one, that is to say, not the middle finger, but the one pointing at you. And if you're watching us on YouTube or on Facebook, you're seeing me point my forefinger at myself, okay? Because that's what the Fellowship of the Finger is all about. We're going to point to you as a criminal, as a violator, as a law breaker, and we are going to make sure you suffer for it, even though we will not allege, as the law requires, evil intent, culpable mind. In Latin, it's called mens rea. Mens rea is guilty mind. We will not accuse you of that. We will simply ignore the fact that the statute requires that we prove it, that we prove in our accusation against you that you intended to violate the law. Every criminal matter has to have that as an argument when the Fellowship of the Finger points the forefinger, or maybe the middle finger. Maybe it is, in fact, the middle finger at you, my listener, for some hazard, some mistake, some minor offense, some traffic offense, right? Some alleged violation of the Transportation Code in Title 55. One of those we're going to find you on, and we are routinely going to accuse you as members of this fellowship, this amazing fellowship of the state being an artificial corporation with no soul and presumptively an eternal life, and a standard that the prosecutor is upholding, and that is of its peace and tranquility, and of the respect and fear and reverence in your heart and mind, you're my listener's heart and mind, of the law, the Tennessee Code, annotated, which runs into 30 volumes or so. That whole thing in a pretense of lawfulness and obedience. Mr. Strong has been in that office, and Lydia Kluel, according to Chattanooga.com, says that he has submitted a resignation on Friday. And there's a little bit of background about him, 2 paragraphs. He ran in 2006 for criminal court judge after Doug Meyer retired, but Barry Steelman won that position. And earlier he had been a candidate for an appointment for another criminal court judge seat in Division 3, and that was for the replacing of Steve Bevel, and someone else got that job. So here's a man. I'm not trying to impugn him or say anything critical about him, just that he is part of this important and vital fellowship. In a way, I'd have to say that the whole party that intends for you to respect its operation as concerning justice, this whole party, with Judge Tom Greenholz and Don Poole and Barry Steelman combined, uniting with the defense bar to ignore an explicit requirement in the law. And because these parties, with the guild of attorneys, the prosecutor, and then, of course, in the middle, the arbiters of justice and the interpreters of law, we have these judges in their robes. We have a widespread ignoring of the statutory requirement for the proving of the guilty mind, and that is in the Tennessee Code annotated 3911-301, requirement of culpable state. Okay, that's the heading in the People's Law. The People's Law, reflecting a biblical standard. Now here we have a question about the role of Christendom, the role of the Christian voter, the role of the Christian magistrate, a question that we've looked at a great deal as we here on the David Tulis show, at Nooga Radio. And we also here at Nooganomics.com, our chief sponsor, we look at a great deal with concern that the system of justice has become unjust, that the system that God ordains to be there, right? He does ordain that there be a post held now by Tom Greenholtz in one division, Don Poole in another, and Barry Steelman in a third. They are ordained to be there. Okay, that's what Romans 13 requires. Romans 13, the most widely abused passage in the scripture, requires the judges to be there, right? There has to be an authority, and of all the officers of the state of Tennessee, those that have the most biblical legitimacy, those who serve God at the highest point and in the best way, are the judges, right? They are the original arbiters. They are the original state. They are the original state. And those such as Montesquieu, the French conservative philosopher, and others who proposed that we expand government and the area of the Renaissance, so-called, that came after the Reformation, and the rise of progressive humanism. They wanted to expand the office of government to not be just the judges anymore, but to be the executive branch and the legislative branch, right? They had enough of God's laws, and we need to have more of men's laws, so we have to have a legislature. We have here in Tennessee the General Assembly. And we really have enough. We need to have not government civil government that is simply passive and waiting for a crime to happen and to render judgment. We can't have that. That's not enough. We have to have an activist government. We have to have an activist, intervening, meddling, regulatory, proactive, and peremptory state. And that's what we have with Montesquieu, considered by many as a conservative, right? He's called a conservative. And his ideas infused many of the analyses of our founders in their desire to have a national state, the United States, right? Headquartered in Washington, the Roman Catholic Federal District, the Square District. And because we have this long progress away from just judges, we have the modern state. And we have here in Chattanooga and Hamilton County the lawful representatives of this state here. We have the executive branch represented in Tennessee, and the legislative branch also we have representatives such as Chuck Fleischman, who is sought to be unseated by a physician, local physician. And then we have, of course, these courts. And the courts now are the object of this requirement for a culpable mental state. And Rodney Strong has left, and I want to ask Rodney Strong, how often did you respect this requirement? Now you're saying, okay, David Tulis, you're causing me discomfort here by citing a law that you haven't really said what it says. Well, it prints out in 4 sections, and the heading is requirement of a culpable mental state. And here's what it says: a person commits an offense who acts intentionally, knowingly, recklessly, or with criminal negligence, as the definition of the offense requires, with such respect to each element of the offense. When the law provides that criminal negligence suffices to establish an element of an offense, that element is also established. If a person acts intentionally, knowingly, or recklessly, period. When recklessness suffices to establish an element, that element is also established. If a person acts intentionally or knowingly, when acting knowingly suffices to establish an element, that element is also established when a person acts intentionally. So it goes on to say a culpable mental state is required within this title unless the definition of offense plainly dispenses with the mental element. There are not many statutes in Tennessee that are called strict liability, but we have them in spades in the federal side, as Chuck Nelly, in a very fine piece from the Foundation of Economic Education just in the past couple of days, has pointed out. There are these crimes that don't require intent are simply wicked. They have multiplied across the landscape. There are thousands of them. They're called strict liability crimes, and they reject the biblical requirement. In the Tennessee Code 3911-301 Part B, it says a culpable mental state is required within this title unless the definition of an offense plainly dispenses with the mental risk. And then the definition of an offense within this title does not plainly dispense with a mental element. Intent, knowledge, or recklessness suffices to establish the culpable mental state. So in other words, the accusation has to be that you intended to violate the law, or you acted with such reckless disregard that clearly you knew the law was there, but you were going to disregard it. So there's a way of proving by your actions, or alleging by the actions you knew the law and were going to recklessly disregard it. So that's kind of a negative intent. So there's a positive intent or a negative intent that the prosecutor has to charge. It has to be charged with every element of the offense. And there's a definition of culpable mental state, and intentional, it says here in the definitions, refers to a person who acts intentionally with respect to the nature of the conduct or to a result of the conduct. In other words, you intend the result, or you intend the conduct which brings the result, when it is the person's conscious objective or desire to engage in the conduct or cause the result. So if you have a conscious desire to violate a law, or you have a conscious desire to obtain the results of that violation, the consequences of it, then you are involving in you have that mental state that has to be proven, and the jury has to agree that it's a fact, right? It is a fact in the case. The prosecutors, they do that with high crimes. That's always, in a murder case, always the issue, right? Lois Lerner, the IRS goon, was not prosecuted because the prosecutor said, well, we couldn't find intent. Why is Hillary Clinton not being prosecuted for digital crimes? Well, she didn't intend to violate the statute, right? So neglect, negligence, and so on, apart from intent or negligent intent, these save her from being prosecuted. Now, why did the high and mighty face these accusations, but the common people don't. They don't have to have that. They don't have that as a defense, right? Now, you say biblical. Well, yes, the court is biblical. The office that Barry Steelman holds is a biblical office, and it is the court is the primary office in Christendom, in the Christian analysis of geopolitics and politics and law. The court is the center of the civil authority, right? That is the center of civil authority. There is no legislative branch. There is no executive branch in a biblical polity. If you just look at the Hebrew Republic, the so-called children of Israel that became a kingdom, its members rejected God and rejected self-government. They rejected being every man directly under God. They would not have that anymore. They wanted to be like the nations around them. If you read Samuel, the book of Samuel, the two books of Samuel. And so God made them become subject to a king. And Samuel the prophet warned the Israelites against that and said, wouldn't you rather be directly under God? And they said, no, we want to be like the people around us. We want to be under someone. We want to have a high king. And he warned them that they would be enslaved by that king. And that is what happened. Saul being the first of them, David the second, and Solomon, and then the kingdom broke up into two parts. The requirement of a mental state is important, and we don't have that now. I would say this requirement, if it were enforced by the judges, if Judge Steelman had said in past years, if Judge Poole had said in years past, and if Judge Greenholz had said in Judge Pass from the criminal bench in Hamilton County, don't bring me a case unless you argue and insist on in your indictment intent, then don't bring it to me. And I don't care if it's a big crime, and I don't care if it's a small crime, don't bring it to me. What would happen? You say, my goodness, we would have a withdrawal of law enforcement. Police would not be arresting people anymore for petty crimes. We would have suddenly the interest of the church. We would have suddenly the interest of, you might say, society in general, hopefully instructed by faithful preaching, Christian people saying, well, we see these people are having a problem. Their offenses are not really crimes, though there may be a statute that would cover that activity. They are simply having a mental episode, or you have someone who's just involved in the sin of distemper. These are not crimes. We will solve these ourselves. Now, again, and look, just go to let's say Chattanooga.com, or go to well, it's convenient to go to Chattanooga.com because it's just convenient for me. There's also a similar platform at the Times Free Press, and that is the right to know page. And look at the charges. For example, Joseph Akins, aggravated child abuse or neglect. Zachary Joseph Allen's the next one, falsification of the results of a drug test. These are very young people. Brian Christopher Anderson, booked on previous charges. We have a woman named Shayna Lenise Baker, vandalism, malicious mischief. We have a man who's a fugitive. There's one under criminal impersonation. There is another one, man, Mr. Branham, domestic assault. Again, domestic assault is this next one, contempt of court, failure to pay child support. Many of these charges are criminal trespassing. What about Joe David Henderson, evading arrest and resisting arrest? Now, there has to be the argument for intent. Without the argument of intent highlighted under the statute in the minds of these three parties, right? The police officer, the prosecutor, the judge, and the defense bar. That's four parties. Without that highlighted argument of intent, then we have many cases. If you insist on that law, if you insist on the biblical model, which I'll mention the basis of in just a minute, you have a cutting off, a slowing down, a stanching of the flow of defendants. You have the police suddenly realizing, well, man, we can't keep arresting people without knowing what they did. You'll have officers who suddenly say we can only arrest people whom we can see very clearly firsthand. Right? There are 500 of us. We're always there. We're everywhere. And we see a lot of things. And we can only prosecute when we see firsthand a real crime. And we see it in such a way that we can prove the elements of mens rea, or guilty mind, or culpable mental state, to use the heading in the statute. What would solve? What's problem would we solve? Let me ask you, what problem would we solve if we have a cutting off, a stanching of the flow of defendants on the intake side from the Fellowship of the Finger? What would we have? It's 800-8949, 800-8949. And this is David Tulis. Well, I'll give you the answer. If you just want to think with me through this, you would have a solving of our Silverdale overcrowding problem. You'd have an ending of the disaster, which is the downtown jail, the Hamilton County Jail, which is a disaster, an overcrowded wreck and mess of a place, a humiliating place to be in, where the man who's sleeping has the man urinating in that stainless steel urinal splattering his face as he tries to sleep. It's so crowded, and there he is on the floor on a mat. That is the condition of that jail, according to a recent report, a recent tour made by the Times Free Press, and reported on a stark and vivid detail, if there ever were one. We have people stacked like cordwood in Silverdale, run by Core Civic, CCA, a for-profit corporation, and the one downtown as well. And is there some value in this as far as the biblical standard? Should Christians get involved in this? The answer is yes. Now, the mens rea standard comes from the scriptures, specifically. Look at Deuteronomy 19, and it's a discussion about the cities of refuge, and about the manslayer. The manslayer can flee there to sanctuary city, right? Sanctuary city is a biblical model, and we should support the concept being replicated today. And whoever kills a neighbor unintentionally, not having hated him in times past, okay, there's the standard, right? Not having hated him in times past, you kill the neighbor unintentionally. And here's the example: as when a man goes to the woods with his neighbor to cut timber, and his hand swings a stroke with the axe to cut down the tree, and the head slips from the handle and strikes his neighbor so that he dies, he shall flee to one of these cities and live. Why? Well, lest the avenger of blood, while his anger is hot, pursue the manslayer and overtake him, because the way is long, and kill him, though he was not deserving of death, since he had not hated the victim in time past. Because it was an accident, it was only a manslaughter. There is no death penalty, and so there is an escape, a protection in the sanctuary city. If it were murder, it would be intent, and the prosecutor in trial in that sanctuary city would have to prove intent, that the man who killed his neighbor hated the man who died, and in times past gave evidence of that. That would be intent, and that would be need to be established. Today, we have a neglecting of this law from God, a law replicated in the Tennessee Code. When do Christians need to see this? Do they not see this as important? Could they not argue this matter in politics, in public, as defending God's standard and also bringing a benefit to Hamilton County? We need to have people who stand on this statute and say, this is God's law written into the Tennessee Code. Let's defend God, let's honor God, let's love God, and make a big deal out of this rule for the benefit of these many victims of the state. David Tulis.
The Tennessee Valley's news talk leader, Nooga Radio, Digital FM 95.3.